Hello students, there is a good news for you. Now you can write the same matter at different speeds. Link of the same is given in the description box. Thank you. Start. The petition has been strongly opposed by learned assistant government pleader by submitting that the reliance placed by the petitioner upon the judgment of the criminal court would not help his case in as much as it is a settled position of law that criminal proceedings and departmental proceedings can go on side by side. Stop. An acquittal in a criminal case does not mean that the petitioner ought to be absolved automatically in the departmental inquiry or that the departmental inquiry against him ought to be dropped. Stop. It is further submitted that the criminal court has acquitted the petitioner as sufficient evidence was not found against him, which does not mean that he has been honorably acquitted. Stop. It is further submitted by the learned assistant government pleader that in his defense before the inquiry officer, the petitioner has categorically admitted the temporary misappropriation and has stated that he could not pay the telephone bills as he was not in a proper mental frame of mind due to the illness of his wife. Stop. He has admitted that the bills were paid after a considerably long period of time. Stop. In the present case, there is an admission on the part of the petitioner which is not so in the criminal case. Stop. The departmental proceedings therefore cannot be compared with the criminal case where the standard of proof is different. Stop. It is next submitted that the petitioner has raised the bills in the treasury to pay the telephone bills and has drawn the amount. Stop. It is only when the superior officer of the petitioner received a notice from the accounts officer of the telecom department stating that the telephone bills were not paid that he started an inquiry. Stop. Only thereafter did the petitioner pay the amount of the bills. Stop. The petitioner has now come out with an explanation regarding his wife's illness which appears to be an afterthought. Stop. Therefore, the penalty of reduction of one increment in the pay drawn by the petitioner for 1 year with future effect is just and proper. Stop. It is next contended that it is not the case of the petitioner that there is any lacuna of flaw in the departmental proceedings. Stop. The petitioner is mainly relying upon the judgment of acquittal by the criminal court. Stop. If there is no flaw or lacuna in the departmental proceedings, the scope of interference by this court would be very limited. Stop. It is next submitted that the scope of a criminal proceeding and departmental inquiry are totally different and both proceedings require a different standard of proof. Stop. Acquittal in a criminal case cannot be equated with the penalty in departmental proceedings. Stop. In support of the above submission, reliance is placed upon the judgment of Supreme Court. Stop. Regarding the refusal of the competent authority to regularize the period of suspension, the learned assistant government pleader has submitted that it is in the discretion of the said authority whether to regularize the suspension period or not as per Rule 70 of the Rules 2002. Stop. In the present case, there is no illegality in the decision of the respondents in not regularizing the suspension period. Stop. It is further submitted that the fact that the petitioner has been acquitted in the criminal case does not automatically result in the regularization of the suspension period stop. Para. Regarding the submission advanced on behalf of the petitioner that the punishment is disproportionate to the alleged misconduct, it is submitted by the learned assistant government pleader that the petitioner has admitted that he has committed temporary misappropriation of government money. Therefore, it cannot be said that the punishment is shockingly disproportionate to the charge stop.